Okay.
Thank you.
So we are now going to go to Commissioner Machadi Ajero for you to ask your questions, Commissioner.
Okay, thank you, Chair. My Lord, thank you. Now, I'll take not more than 30 minutes with you. And I'll start with the sample writings, my Lord, that you provided.
Yes, sir.
Now, you are referred by my colleague, Commissioner Majanja, about this case of Professor Misia Manuguti Kadenyi.
Yes.
I'll come to that later. But there was a similar case that you had decided, which you provided a sample writing. This, the one relating to Samson Olekisir Koi.
They are cousins.
Yeah, but Masai Mara University.
Yes.
Now, and what I noted in the same case, of course, you also made reference to your personal case, where you also referred to your colleague judge as my friend and brother. I'll come to that later.
Please do.
But when it came to the kind of awards that you made, I couldn't follow, and I'm asking this because I need to understand your jurisprudential leadership if you become the Honorable Chief Justice. Because one of the things that you did is that this was I think he must have been the Deputy Registrar Administration in the university.
Yes.
Now, who had been terminated.
Yes, sir.
Now, you started by saying, of course, you reinstated him, you ordered that he be reinstated. But one of the things that I found I couldn't understand, but you could explain to me, is that the date when you issued the judgment, you said that I hereby order that the petitioner reports back to work tomorrow, the 1st February 2018 at 8:00 hours. You know, basically
Yes.
saying tomorrow by 8,
I appreciate.
you're back in the office.
Yes.
Now, which I was wondering that whereas of course you'd be entitled to grant that kind of an order, whether as a judge you don't see any practical difficulties in that, in not granting at least some reasonable time even as you are granting these rights, balancing it with some reasonableness. Because you'd imagine if somebody has been away for over 2 years, you know, the employer would even require probably to put in a desk, arrange some administrative measures to make it practical for this order to be effected. What could inform your decision to be so drastic as not to even grant that reasonable time?
I don't know whether you want a very direct question, because I can give you a background.
Yeah, but not too long, so that in the interest of time, but you have your day, that's all right?
Yes, I have accused myself of being the judge in that court who is all too free on reinstatement. Having said that, with my issue in my reasoning in mind, that employment in Kenya is like a matter of life or death. Whenever you can get back to work, please get back to work. Two, the immediate date. In this case, we have established a case of unlawful termination of employment. That is ugly enough. You've been out of work for so long. Another very ugly situation. You've gotten judgment in your favor. The practicability of, giving you time to return to work, to me, would not make a lot of sense. Because the employer is there, he has offended you, he has transgressed your rights, he has made you suffer for no good reason. What is this so critical situation, which would be worse than what you have suffered, that would require that we give you 2 months to resume work, etc., etc. I have never thought that it is impractical. I've always thought that it is immediate, and that is what I have done in all my cases of reinstatement. I have never considered that I am being offensive to the employer. If the employer finds that he is not ready or etc., I have returned your employee. Deal with the situation. That is a domestic matter. The judge has done his work. And to me, that makes a lot of sense. If I am faulted by other quarters, I am agreeable.
But then in the same decision, you went ahead and said the respondent be and is hereby ordered to meet and pay the respondent's salaries and allowances owing but unpaid during his suspension, which is all right. So basically you're compensating the petitioner for the time that you found that the termination was unlawful. So you are reinstating them, kind of like putting them back to the same position they were before termination.
Yes,
but which is fine. But my problem again now, which I couldn't understand, of course I'm not the judge here, just need to understand your reasoning. You go ahead again and say you're also awarding 6 months' salary as compensation for unlawful termination of employment. So you are not only giving the salary during that time, plus all the allowances, you are reinstating them to that position, but you're also adding another burden of another compensation on top of the compensation you've already awarded. So, I mean, I'm not really getting, what is the reasoning behind that and the fairness in it, the justice in the matter. Could you kindly just expound on the jurisprudence behind that?
The issue of a 12 months compensation, which must not necessarily be 12 months. 12 months is the limit. You could do a month, you could do half a month, you could do 3, 4, 5, 6, etc., etc. Under Section 49, 1C of the Employment Act, is not in entirety the total compensation available to a case of unlawful termination of employment. The judge has the discretion to look for other remedies which are available and which have been prayed for to offer. And this will depend on the circumstances of the case. The judge exercises the discretion depending on the circumstances of the case. By the time you do the matter and finalize, you've gotten the gist of the matter, you've gotten the involvement of the parties, etc., etc. That is what dictates what you offer the aggrieved party. And in the circumstances of that case, we are compensating unlawful termination differently from any other issues of compensation that may have arisen in the circumstances.
Yeah, that's all right.
That is allowed.
Yeah, Judge, but it's only that again the discretion must be exercised, should not be exercised whimsically. And again, you see, you already compensate the person. But I don't want to make it an argument, I just need to understand your jurisprudence. But now, you've reinstated the person, which is fine. You say they be paid all their salaries and allowances, which again is fine, I don't have an issue with that. But now again you are saying a permanent injunction be and is hereby issued restraining the respondents from commencing any process towards replacement of or replacing the petitioner in the position of Deputy Registrar Administration. Now, if they're already back in the position and you've compensated them, but you are saying that there should, basically what you essentially are saying is that there should not be any process towards replacement. So if this person misbehaves again, it means then that the hands of the employer are tied. They can never start any process. So again, what is the reasoning around that?
Thank you, good counsel and commissioner. I relied on the historicis of that matter, the background and the data available, the evidence in the matter. What did I hear? What did I know? etc., etc. The environment was so hostile that we had to safeguard the position of the employee when he goes back to work for various reasons which are very, very clear, that that was a very, very hostile affair. And two, the issues which they were fighting were not issues which were industrial. all evidence will tell you that it is personal. So when it is personal and you can see it so clearly, you may not be able to declare it or say it, etc. What you do is issue as much safeguards as are possible to the employee. The employee and the employer are not equal. This is an interplay of labor and capital. Capital is always superior. So you safeguard you safeguard labor depending on the circumstances. You safeguard the capital, or you remedy their situation depending on the circumstances. In that, under those circumstances, and knowing the matter the way I did, I was convinced that that gentleman required, the claimant required security in his employment.
Yeah, but you see, Honorable Judge, when you are telling an employer that he should never touch this person for as long as they're an employee again.
Oh, thank you.
Basically,
thank you.
you're tying. But let's move to the next.
I could answer that very briefly.
Yeah, please go ahead, Judge.
You choose.
Yeah, please go ahead, Honorable Judge.
That was not permanent in that sense. In fact, when he resumed employment on day 3, if he missed, they would restart the process. That was supposed to deal with that situation, the situation we were adjudicating, not anymore.
Yeah, but you see, the way your order was framed had the opposite effect. That's the problem I have, and that's why because I'm asking you jurisprudential questions, because you'll be the leader of jurisprudence in the institution. So that's why I'm asking that question. But now, let's test your decisions, because I had to again now do a bit of research, because this matter of Professor Misia Mangut Kadenyi, the one you asked by my honorable colleague. Now, I went ahead and actually noted that it's a matter that was a subject now of the Court of Appeal. It didn't end just with your court. And now what I noted is that, for instance, the award that you had given in this Professor Kadenyi case, apparently what you had done is that you had awarded compensation, you had picked a salary, which you awarded against the employer, which was not supported by any evidence at all. The evidence was based on the evidence that had been given to you was showing a monthly salary of 333,640, but you picked instead 658,112. In fact, the court said, we have carefully gone through the judgment of the trial court, and there's no indication at all where the monthly salary of Kenya shilling 658,112 is taken from. There is therefore merit in the submission by the appellants that this figure is unsupported by the evidence, and we therefore set aside the learned judge's finding the monthly salary of 658,112 and substitute therefore with a monthly salary of Kenya shillings 333,640. So you can see a problem whereby you are probably making a decision based on other considerations, probably emotions, and I can see you keep, in all these decisions, you keep quoting your personal case against TSC, which again, in this case, you are being accused even by the appellant, saying that you seem to be relying more on your personal experience with the National Teacher Service Commission, and there seems to be anger and, which is because of probably you are feeling that you are mistreated, you are now transferring it when you are now deciding decisions. So, I mean, wouldn't you consider this to be a serious indictment even by the Court of Appeal regarding how you are making decisions of a mandatory nature against employers and supported by evidence? I don't know what would be your consideration to that, Honorable Judge.
On the first issue, the issue of the amount which was multiplied as a compensatory figure, the 629. Section 49(1)(c) of the Employment Act covers that. Section 49(1)(c) talks about gross salary, not net salary. The employment law does not know net salary, because when we are compensating you for unlawful termination of employment, we go by the law, and the law provides that we use the gross salary. So what a judge on finding of a situation of unlawful termination of employment would look for on the pleadings is all the itemization of dues. I was paid 4,000 shillings as a basic salary. I was paid 1,000 shillings as a house allowance. I was paid 500 shillings for a transport allowance. That is what you add up, and that is what I did to get to a figure of 629, including the car allowance, which was, if I remember right, 129,000 shillings. So you add all that, you must accumulate all that to get what we call the gross salary. And that is what now, in your discretion, 1 month, 2 months, 12 months, 10, blah, blah, etc., etc., you use as a multiplier effect to get the figure. But the Court of Appeal, we may not be able to correlate it. It buys us insofar as that matter is concerned.
Yeah.
But going back to, to ourselves, we would always want to ask ourselves, which is the earlier? Is it the Court of Appeal and his findings in the professor's matter, or Kisirkoi's matter, or the Employment Act? A big question.
Yeah,
I have answered your questions. If I haven't, I could
well,
continue.
you know, the principles of stare decisis bind you. This is the Court of Appeal. Now, again, then, my lord, again, you see, in Samson or like Kisirko, you made that order that the employee reports the following day. And what I noted is that in again Professor Misia Kadeni's case, you did the same thing, ordered that, report tomorrow. So in the Court of Appeal, this is what they had to say about that issue. We wish to state that in instances where the court is satisfied that an order of reinstatement is deserved, it is not prudent to direct that a claimant reports back to office within a day from the date of a court decision. Such a drastic order is likely to present considerable implementation challenges to an employer. In our view, a reasonable period, depending on the circumstances of each case, ought to be given for the reinstatement to be effected. So you can see when the Court of Appeal is saying that is too drastic, there has to be reasonableness. And you see, the reason why I'm asking this is because you'll be our Chief Justice if you become one. Now, the issue of reasonableness now starts arising in your decision-making process. I don't know whether that makes you change your mind regarding those kind of drastic order that you keep making, that, I'm issuing an order, I want it implemented immediately without considering the challenges that would arise from the implementation. Not just in the decisions, but even in your day-to-day decisions that you could make here as our Chief Justice.
Well, thank you, good Commissioner. We are open to learning. That is one, first and foremost. But like I said earlier, that is what I have practiced throughout my career, 10 to 9 years in that court. Nobody has raised an issue on that in the past. The matter you are referring to was not an ordinary matter. There were other, side issues relating to the matter. As the Chief Justice, we would not like to do anything which hurts anybody, even as judges of the employment court. I would never have imagined that when I tell somebody to go back to work the following day, there would be an issue, because employment is contracted. The employer could go back the following day and is given a week's leave. In any event, he's been away for so long. The employer could go back the following day, and then another different arrangement is made. All those factors come into my mind when I said that. The agency I created, not because I want to make it impossible for anybody, not because I want to punish anybody. I want to, it's an indication of urgency. It's an indication of seriousness insofar as labor relations is concerned at the workplace. I am telling everybody that good enough, you are secure when you harmonize your relationship with your employees. When you don't do that, and you deal A, B, C, and D, what we shall do is we shall tell them to return. And not because we want to be offensive, but because it is their right. And but primarily, I think the whole matter is open to the employer and the employee to deal with that aspect. And if we don't have impossible situations, because we are human, when it becomes an impossible situation, there's no employee who takes in charge of an industry. So if he's told by the employer now, you can come back in 2 weeks, 3 weeks, etc., that would be okay. That would be good practice. You will not insist that it just sticks there and it stays there, and bears the fruits of immediate reinstatement.
Okay, Honorable Judge, just 2 more points on that decision.
Please.
That we move to something else.
Yeah.
Again, you see the same decision of a prof. Now, the evidence was very clear that the position of Deputy Vice Chancellor, Academic Research and Student Affairs had already been abolished. But that notwithstanding, you still went ahead and said that I'm reinstating you to this position. Now, again, I'm not able to understand why you would insist on reinstating somebody to a position that no longer exists. And in fact, to that effect, the Court of Appeal again said, considering that the position to which the respondent had been appointed had been abolished, we think that it was not an appropriate case to order reinstatement. Balancing the interests of the parties tilted in favor of not ordering the reinstatement, we therefore allow this ground of appeal. So why would they take for the Court of Appeal to be the one now to see that it doesn't make any practical sense at all to order reinstatement of somebody to a position that does not exist? So again, I'm not understanding the reasoning, around that.
If you get to the background of the matter, you appreciate that that was not a matter industrial relations. The issue was not industrial relations. The issue was personality. You versus somebody else. The Vice Chancellor versus her deputy, etc., and it was not even more personal. It was strictly a personal matter.
Yeah, but
so when it comes to me, and I take that evidence, you say that the place, the position has been abolished. That is your evidence. The other one says that no, the position is not abolished, and if it is, it was not done in good faith. So where does that leave us? When we get a situation like that one, we have over-insistment in that kind of circumstances, we have the most obvious choice. That one of getting back to a position similar to, getting reinstated to a position similar to what you have. But looking at the historicity of that matter, I thought that we should not encourage personalization of industrial relations, of employment issues or employment contracts. Let her return to that office in the same position. The balance belongs to them. The Court of Appeal, I
agree with you, but you have to always remember that you have to remain a judge based on the evidence, the facts, the law. And you see, this is a case where there was an opportunity for either reinstating to that position or the position of the professor to continue teaching. You reinstated both. The first one was okay, even the Court of Appeal agreed that the one of the professor, that's fine. But this other position, because teaching is always teaching, so you can't say you've abolished teaching, so that's fine. But you reinstate someone to a position that does not exist. Don't you think then that you're putting, the employer in a situation that they can't actually be able to comply, making orders that are in vain,
I am saying that there was evidence wholly on the situation on the ground. There was evidence to the extent that this matter was not so much employment or industrial relations. It was a matter which was, personal. The Vice Chancellor and the Deputy Vice Chancellor.
Okay.
etc.
Yeah.
And that is why I dealt with it that way.
All right, we leave it at that.
The Court of Appeal has come its own style.
Yeah.
It has taught us one or two things.
Yeah.
I had other options, which I chose not to take for various reasons. I get it.
Yeah.
I am
Then this
guided.
issue of keeping on quoting your case was also submitted on, extensively. It was found to be, whereas it's a matter of your choice, but not tidy, as was also observed in a passing. But now let's leave the cases now. Let's discuss now you as an individual, so that if you come here with us, be with us, we can see whether you can be able to do the job. Now, you asked about the question of collegiality in the Supreme Court, where it would be now the president of the Supreme Court. I would want to understand, like, for instance, if the disagreement among the judges there, and you be now their president, and I'm talking about disagreement, not about personal disagreements. I'm talking about disagreements on decisions. Now, I would want to understand, again, not in so many words, how you'd want to, which way you'd want to go in terms of managing it. And I'm asking this because, not because of our Supreme Court, because I took interest in some matter in the Supreme Court of US, Small versus Memphis, light gas and water, that is the case, where the Supreme Court declined to take over to take an appeal which sought to review a famous case of 1977, which would have reversed a precedent that had been established in the US. But two of the judges disagreed, with the refusal by the other judges, specifically Neil Gorsuch and Samuel Alito, and they actually went public, wrote a decision totally disagreeing with their colleagues and all that, and went public. And of course the other judges were quite unhappy with that kind of with that line of action. How would you deal with a situation like that, and what would be your preference in managing a situation like that?
This is an experience I may not have. It's an experience I am going into immediately when I become a Chief Justice of the Republic of Kenya. So how do you manage that? At our induction course many years ago at the JTI, we were taught elaborately the subject of collegiality by one of the commissioners here, the Honorable Attorney General of the Republic of Kenya. And this simply means creating brotherhood. Judges are limited in decision making. I mean, there's independence in the decision making. But my understanding of collective decisions, like the ones of the, big bench decisions, is that these are negotiated. There is a conference, there's a conferencing, and after conferencing, they get to level 1, maybe level 2, agree, and if there are any dissents, the dissents also take their place. So, in the circumstances of that kind of situation, however hard the matter is, the judges of the Supreme Court have a duty to deliver justice or to make determinations in all matters, regardless of the intensity or difficulty. We cannot just come out and resign and tell Kenya, no, this one is beyond ourselves. So you see to them.
Okay, so you'd agree with me that experience in managing, even a bench, you said you've never been in a situation whereby you've sat even with colleagues in one bench. I think that's what you said, that also is it's necessary to have that kind of experience, which probably
When we get to the Court of Appeals, to the Supreme Court, I'll be one among its equals.
All right.
There are many judges there who have vast experience in these matters, vast experience at the Court of Appeals, vast experience at the High Court. So there's nothing we lack. It's just a question of teamwork. You can, get off the chair over the Supreme Court in a session where we are doing the conference, and hand over to somebody else who takes charge and guides everybody and leads and teaches. In fact, a colloquium is an issue of teaching, exchanging ideas. Sorry, not a colloquium, but a conference. Is a teaching and exchanging and sharing differential, merging differential, etc., so that you are able to create a consensus. And that is where we are. The issue of being Chief Justice and Chairman is just peripheral. I mean, this is a team of equals. And we must always recognize that there are two types of seniority, insofar as the legal profession is concerned. The seniority based on the date of admission to the role of advocates, seniority based on the date of appointment as a judge, the date of entering that role. So those must be taken into account. But overall, knowledge, expertise, experience, goodness, cleverness, and what have you are not an issue of possession. They are an issue of knowledge. Knowledge is basically knowledge. You know or you don't.
My Lord, I was referring to the experience.
Honorable Judge, maybe you can be addressing the commissioner asking the question. With respect. It's good to address the commissioner asking the question first.
I was referring to the experience. You see, the High Court judges, sometimes you find that a bench has been impaneled, so they manage that. Same thing also in the Court of Appeal, of course, they deal with benches, and Supreme Court also they sit, and many of them. That's what I was referring to. But now again, I'm wondering. You said that when you were asked one of the questions, I think it's when you were asked about leadership, and you said that you've not sat in any big office, and you actually talked about having risen up to, I think, senior state counsel, and then you referred to being a senior, I think, legal officer or something at the TSC, then you became a judge in industrial court. Now, so I'm wondering, if we give you again this position of the Chief Justice, which is quite senior, where you are responsible for for a lot of resources, a lot of issues, it's an arm of government with many responsibilities. Now, I don't know what you do to convince me that the learning curve wouldn't be a challenge, because we can't take chances. It's a position. You see, there's a position that there's also very high expectations from Kenyans, the members of the public. Now, I'm just wondering, as the Judicial Service Commission, how would I, for instance, as a commissioner, account to Kenyans that I've given to my Lord, yet the burden of proof on his part that he is equal to capacity, not based on what he's telling me that he'll do, but based on his past, that he can be able to prove that he's equal to the task. How would I be able to account to Kenyans? I'm asking this with tremendous respect, not to demean what you've done before, but I'm just saying responsibilities versus what you've done and the office. How do you convince me so that I can be able to give you marks with that in mind?
In the first parliament, 1963, when we got independence, most of our cabinet ministers were less than 30. They were politicians. We had not been, we had not ruled ourselves whatsoever, but we walked through. Mzee Jomo Kenyatta was a president. He has not been a president whatsoever. He was just an activist, a politician, a freedom fighter, but we walked through. What we are saying is that to gauge what I'm capable of doing as a Chief Justice, look at what I did in Sharia House in 1.5 years between 1985, 1st of August, and January 1987. Gauge that, look at it, etc. How did I relate? How did performance, etc. Whom did I lead? Whom didn't I lead? Because even when you get people from, your clients coming in and working happy, and you do a job and you get results, there must be a sizable amount of leadership. We have not been in these places or in big office because nobody gave us an opportunity. You cannot hang us for that. Look at my personality, if you are able to, I don't know, that will be difficult for you as a commissioners. My personality, where have I been? Go to my village if you can at Chuka. Look at what I do. Do I own a cow or two, and how do I feed them? Etc. etc. Leadership is not an issue of office. And if that is not answering enough, learning does not take centuries. It is just a question of if we landed into that office today, would be able to sit there. Two, you are working with a team. I must not be ICT. I must not be HR. But we have people there who are HR. If I find them inadequate, I'll be able to bring expertise. So you, a leader, just sits there and implements a policy and shows the way. I went to the KIA for a course a long time ago in my TSC days, and we were taught about the difference between a leader and a manager. This is the difference. A leader thinks, states, and leaves. A manager is left by to implement. So if you have the idea, the implementation is not an issue for the leader. You have the idea and you say it. What you do as Chief Justice would not outrightly abandon management. You'd have to combine the two and be on the lookout. But we are saying that you cannot do everything. I am not a teacher, but all the schools around here would get taught if I was in charge of them, because I would get teachers and good teachers to do that. So you incorporate and you apply whatever resources, human resources you have to be able to get what you want. You lead, now, and others follow.
My Lord, now you said, again I'm picking this from what you said. And
please.
I only have 3 more questions. That after you came back from the political seat that you attempted to get, you started legal practice, which lasted for 11 months. I'm just quoting you verbatim.
Please.
11 months, and then you decided to go back to employment at a Teacher Service Commission.
Yes.
Now, I'm just trying to understand what made the law firm not last beyond 11 months. Nothing wrong with that, but I just want my understanding so that I can see how to place you in terms of...
answer. I left the Sharia house to go for NITHI. NITHI was disastrous. I realized that I did not have any future. I was not a politician. I would not cope with it. So I came back to Nairobi to pursue my career, my profession. In the absence of anything else, I opened an office. I have always known that I am not a practitioner. Legal practice, private legal practice, hands off. That is not my line. There are so many other things I can do in law, with law, but not a successful legal practice. I'm not your personality. I am myself. I have my limitations. I have my gifts. Private legal practice is not one of them. That is why you realize that after my horrid departure from the TSC, I go to Ongata Rongai and sit there and start a practice as a pioneer counsel in that place. 3 years down the line, 2 years down the line, I began teaching. Because for me, teaching is more of myself than a legal practice. In fact, if I had continued, I would have abandoned the legal practice altogether, because that is not myself. That is not my gift. Those are not the areas where I score, and go to precisely where I score. 2, all this time I had realized that I am a public servant. That is why I sit here today. That is who I am, and that is the best. If you wanted to get the best result in me, public service.
Yeah, but you see, again, now my worry is that we could give you now the position of Chief Justice, and you are unable to, being a judge is one thing, but being a Chief Justice with all these many responsibilities is a different thing altogether. It's a different ballgame. So, again, I would be worried that perhaps, you may not be able to manage that position. I keep reminding you that for us, whoever we appoint, we must be able to look in the eye in a Kenyan and say, this is why, you know. So wouldn't that be one of the reasons probably that could create some doubts in our mind that perhaps we could give you that 11 months later you're not able to manage? And that time, and you see the removal process is a different thing altogether.
No, I don't see it that way.
Mm-hmm.
One, I don't see the link between, a Chief Justice and a private legal practice. Good, you relate with the practitioners out there, but you're not practicing yourself. You know how it is done. The only dilemma is that you cannot do it on your own. It is not your line. You may not be interested. You may not even know. You cannot be hanged for that. This is a public office, Chief Justice of the Republic of Kenya, which, any able leader would be able to do, particularly if you are fast, like I am. You'll be able to sit there and get everything connected. You have everybody that you require. And if you don't have, you could always bring them in so that you use them to get what you want. You are the leader. Legal practice, private legal practice, and this office, this grandiose office of Chief Justice of the Republic of Kenya, to me, not.
Okay. Second last question.
Please do.
Now, you see, if you become the Chief Justice, you'll be also the chair of this commission, JSC.
Yes.
You'd actually come here and now be a primus inter pares. You know, you'll be the first among equals. Now, I'm just wondering again, because managing us, you can see we're all from different, we are representing different constituencies. But you have to put us together, and we are one cohesive commission, chairing us, and all that. And of course, it's not an easy task. Eh?
It will never be easy.
Now, tell me, what is it that you think you have that, gives you that ability? Because, you see, this commission, of course, it has immense responsibilities vis-a-vis the institution of the judiciary. Because, again, I'm looking at your CV, I'm looking at what you've done, and I'm still not seeing what is it that can be able to put you in that primary position of being able to make the commission function in a way that it's able to undertake its duties. And as you answer in that, this is the same commission, without getting into many details, you've already had so many issues with it, which you are aware of, and then that are still outstanding. So I'm still wondering, how would that work? Because, see, again, you can see the Court of Appeal is talking about tidiness, even as you are making decisions, as you are making certain considerations. I'm just wondering, how tidy would that be? That our chair now, will the chair come and start dealing with his issues first with us in the commission, or shall we get down with the business of making sure the commission is able to deliver on its obligations both to the judiciary and the Republic of Kenya?
The issue of ability is not an issue whatsoever. The Judicial Service Commission has its obligations, which are dictated by law and practice. Who is in charge or not in charge would not make a difference. In this sense, if we are committed to what we must do to fulfill our mandate as the Judicial Service Commission of the Republic of Kenya, and our roles are explicit, what it would require, is that we move on to create work plans for implementation and acquisition of the end result. I would lead in that. But I would believe that I'm leading 11 others who are committed, as knowledgeable, who have the goodwill. So that where I sleep, you raise me up. Where you sleep, I raise you up. So it is not this work. If the entirety of the Judicial Service Commission that we have today left, in a week we would have another Judicial Service Commission, and there will be continuity. the issue is not, where you have been. The issue is, are you able? I believe I am very, very able. I have a proven record. Go to Chuka, you look around, you see what I have done. Even, my coffee shop, I will tell you, this person is able. etc. I have answered. How satisfactory the answer is?
So my last another question, my lord. You know,
sorry, if you allow me, good commissioner, there is the second limb of the question. My issues with the commission. Will you allow me to answer that?
Yes, go ahead.
Go ahead. Thank you. My issues with the commission are not personal. My issues with the commission are as such issues with the commission. The commission would have the ability to deal with all those issues independently and freely, even if I was a chair. I'll just get out. That is what we do in the church or in any other meeting. If you are conflicted, or it is a matter which conflicts you, you take off and the others make a decision. Good enough, yes. 9 complaints. I do not generate complaints. Complaints are managed by the commission, and we shall not take that away from them. So even as a Chief Justice, as late as the other day, we knew and we had, it was public knowledge that the Chief Justice had complaints which the JESC would even ask him to answer for consideration. None of us is immune. And I thank God because Kenyans are at liberty to raise these issues. And we shall not take that right away, because that is what our independence is all about. We are accountable to them. They can raise 1,000 issues against me. I'll answer. If I fall, I'm indicted, good enough.
I'm satisfied with that.
So, my issues do not have nothing to do with
I'm all right with that, my lord. My final question.
Please do.
You see, the hard reality, regardless of what we may think, whoever is the Chief Justice must be somebody who must attract the respect of the peers. And of course, even as they enter and they take that position, Kenyans can say, yes, the person must come up with that, it must be somebody who people can say, yes, that's a person who is befitting of the office. I'm not saying you don't, but do you think you have that? That's all. That's my last question.
Thank you, and thank you again. We are looking for, yes, it has been said very loudly, and I know that, and I'm not cheating myself. I can mark myself 90%. Kenyans have loudly said that is a man, the man of the moment, in the airways. I'm not talking about commission of Kenya. No, I'm not talking about radio. I'm not talking about TV. But if you feel the air around Kenya today, it is very, very, very clear. We have. I said that this is a man. Did you see the 2 reviews I had on the newspapers? The one on the Standard immediately after Easter, and the one on Sunday last. That is what I presume is the voice of Kenya.
Okay, thank you very much, my lord. I wish you well.
Thank you, and welcome.
Thank you very much, Your Honor. I will now request the Commissioner AG to ask you questions.
Thank you, Honorable Chair. My Lord Justice Marete, I would not wish to belabor you with too many questions, because many of which I would have asked have already been put to you and you've answered them. But just to follow up on what Honorable Commissioner Macharia has just been discussing. you seek this office against a backdrop of 38 or 35 odd years of experience. And you have attempted to persuade us that you are indeed the man for the moment. And you have sought to demonstrate that you would be able to learn and learn very quickly. And you said, my Lord, that you would engage the public as well as the judiciary staff, make them happy, motivate them, etc. Would you be pleased to tell us, Your Lordship, which existing organs within the judiciary currently which you would engage to enable you learn quickly and to achieve the mandate of the office? There are various organs existing within the judiciary as we sit here. Which are they, and how would you engage them?
One, we have offices and officers. The office of CRJ is very instrumental in the running of this institution. She's the CEO of the institution.
That's one.
The office of the very able Deputy Chief Justice. She's been in that position for long enough to be able to even be Chief Justice herself. It will require a hand-by-hand contact. For a year, for a month, 2, 3, 6, 1 year, etc. That collegiality and the cordiality between those three offices is like the issue is resolved. Because through the Honorable, the CRJ of the Republic of the Judiciary of the Republic of Kenya, I'll be able to access all the other human resource which is available through reports, through any other means. The CRJ, the time she has been there, knows the judiciary and its operations throughout, inside out. And being here and available and knowing her personality so well should be a vital asset in helping us walk through this journey. The Deputy Chief Justice is here. The Commission is here in entirety, a big force, Judicial Service Commission. You didn't go to the other associations, the independent associations for like the KMJA, the Kenya Women Judges Association. These are institutions and organs which would be able to tell you and give you what you may require in terms of learning, and be able to support you as and when you need it. They are your colleagues. You are not their senior. I would be able to work within a class 2 kid today and transact business. Why wouldn't I be able to work with everybody? Inequality, that is my terms of trade. Everybody who deals with me we deal at the same level, at parity. So all this crowd here of a senior officer, the JESC, KMJA, the association representing judiciary staff, all those organs, if I wanted to borrow from them, it would be instant. And I believe they would be willing to lend a hand. And there we are. The judiciary, this is not personal. The Chief Justice is just there as a figurehead. The whole thing belongs to all of us in equal shares. And Kenya, equally.
What about in relation to the courts, my lord?
The courts and the administration, we have heads. The president of the the Court of Appeal. We have the various, principal judges, the principal judge of the High Court, the principal judge of the Employment and the Labor Relations Court, the presiding judge, or in quotes, the principal judge of the ELC, big consults. Beyond that, you can even go to the individual judges. I'm accessible to virtually, as Chief Justice, virtually everybody. And this place is rich. Do I repeat that? Look at who is sitting besides you. A giant, insofar as performance is concerned. An intellectual by excellence. And here we are. There's nothing we lack whatsoever.
Thank you very much, my Lord. Now, you discussed the jurisdiction of the Supreme Court in relation to election petitions. Would you be pleased to tell us, my Lord, whether you consider that jurisdiction should be expanded or restricted generally in the Supreme Court, but not in relation to election petitions?
The Supreme Court should be very, very guided and very guided in the way is the jurisprudence in the way the jurisprudence on election petitions, and generally every other matter is concerned. We read from Kenyans or even other scholars outside this country that as at the time of the elections in 2013,
my Lord, please, you explained the aspect in relation to election petitions. I should ask you now to deal with the jurisdiction of that court outside the framework of election petitions. Should the jurisdiction of the court be expanded or restricted, and if so, why?
I would not think that it should be expanded, because one, let's look at this at the basics of your question. The Supreme Court has expressed itself on that, and the ratio decided is to the extent that in all these other courts, the High Court, the Court of Appeal, etc., we have competencies which will be able to deal with any matters constitutional. I should even deal with that down to the magistrates' courts. These are professionals who have the capacity and the competency to deal with matters constitutional. That being the case, and looking at the circumstances and the basis of the Supreme Court, I would think the safest thing would be to narrow it, not to expand it, even in these other matters, so that you are restrictive and you are able to guard what you take in and do it very, very well, so that you become a guide. One, you become an authority in the region, and you are able to meet the expectations of those who created the Supreme Court. Because the Supreme Court has got its own histories, and there was that which it was intended to cover. I would implore a very, very conservative and restrictive approach to jurisdiction in the Supreme Court, so that we are able to, one, cope, two, allow everybody else down there, the Court of Appeal. We are talking about rival jurisdiction as we speak now in the out there. I mean, we are talking about a rival jurisdiction, things which are extremely dangerous. Let's allow everybody to do their bit. Let the Supreme Court do what it was intended to do by the drafters of the Constitution through, the people of Kenya.
What was it intended to do, my Lord?
Primarily, the Supreme Court was intended to deal with the issue of a presidential election. In fact, if you are lay and you heard of the Supreme Court in 2011, 2010, etc., post-Constitution, what everybody told us was that that was the most critical matter. But you know that cannot be done forever. The Supreme Court becomes a lead court, and it was intended to be that, lead in terms of jurisprudence, so that you are not doing 1,000 matters. Do 5, 10, 100, and do them so well that anybody looking at them will be saying, I was guided on A, B, C, D. The thinking is brilliant. These people had their time in so doing. They were not rushed like we are rushed by backlog. So that you are able to come out clean and guide Kenya on its governance patterns. The framers of the Constitution put it right. Issues of constitutional interpretation, issues of constitutional interpretation and interaction, good enough. But now, when the Supreme Court itself now sits, what does it interpret this to be? And when it does that now conform with the expectations of the drafters of the people of Kenya?
And my Lord, how would you then, if that is your belief, what leadership would you offer in that jurisprudential development?
One, the issues which are in contention, the issues which have been raised by the Kenyan public and any other interested party, international, scholars and academia, etc., I would subject that to a public debate. They would be thrashed out, and they would have a policy which is not guiding on the decisions of the Supreme Court. We cannot tie the Supreme Court. As we do it at a public level, the Supreme Court would also be sitting to think, would create a situation of reflection, a situation of introspection, a situation of consultation and rethinking, so that if we are convinced that there is a problem, we are stifling the other courts, we would deal with that freely and openly. But it would require the Supreme Court on its own to sit and reflect, introspect, and generally see what is available and what is offerable insofar as what we have today is concerned. Very convincing, very able, and a very good jurisdiction, if you ask me. But issues have arisen. If you read any of those matters and opinions and decisions, they are fantastic. They sound good and etc. 1,000%. But now when you come to the ground, other intellectuals are raising issues, and we cannot ignore them. They are part of our stakeholders. They are Kenyans. Quietly, we have issues even which are internal. Like the critique on my decision, the Court of Appeal judgment made very firm interventions on my judgment. This may not be that formal, but we have other areas which may be feeling uncomfortable with what the Supreme Court is dealing with and the extent it is. So we bring everybody on board, we thrash out the issues, we make recommendations and solutions, we hand it over to the Chief Justice, not as a direction. The Chief Justice would take it up and deal with it as a style with his judges at the Court of Appeal. Because the Court of Appeal can only recreate itself. We cannot go there and hammer them into recreation.
Thank you very much, my Lord. Let's move on. Just a couple of more questions. You've heard this phrase, why hire a lawyer when you can buy a judge? You familiar with that?
Very familiar.
If you do become Chief Justice, what would you do differently to deal with corruption in the judiciary?
One, surveillance. It is one thing to say that you're dealing with corruption, and this is a very funny issue and a very, say, sensitive issue, because whoever would listen to me answer this would pick quarrels with me if they were in that side. Thank God I don't belong there. So, put effective surveillance mechanisms so that we are able to detect these cases. You know, corruption is a very personalized affair. It's not an affair which, is public or publicized. It's like any other very personal, areas of our lives. I don't want to mention them here. So that this two-way matter, unless the Chief Justice and his officers do very strict surveillance on this, and also deal with it very firmly, because we cannot sit here and pretend that we are serving justice when we are doing things under the table. If you are not writing a genuine judgment, then you have no business writing any. You should walk home. So that when these things are influenced by not even corruption, call it bribery, is that cheap? By bribery, you are telling us that we are not in serious business. So the Chief Justice should put his foot forward, should do surveillance and employ any other methodology, including the EACC or any other mechanisms to arrest corruption. The Kenyan public would never be happy like I would offer them if they were still being asked to pay 20, 30, 40 shillings, 1,000, 2 or 5. And it's so unfair, so immoral, that I will not kick anybody, but I will not be amused. I'll do everything possible within my means to eradicate this entirely.
My Lord, what mechanisms would you employ to ensure that corruption cases are heard and determined expeditiously, which is not currently the case?
Did we agree that, or did I submit that I would, in the next 3 years, I'd want all my matters determined in 360, or if you want to increase that, 365 and a quarter days, so that in every 12 months, a matter which has been raised with us is determined. We have an issue with the criminal justice because it is a broad spectrum. We have an issue with corruption cases. Corruption cases and what is happening in the Supreme Court, elections, is a class affair. It's very rare that you find people who are involved in corruption being my brother who does his beans and bananas at home. Not him. It's somebody like me, you, and everybody else. And do we call it class? People who are up there, the elite of this society. That is why it becomes very, very difficult to deal with this. But do we have judges in that court? Do we have adequate staff? That is the first question. Are they happy? Have they raised issues why they are not able to deal with these matters? You'd have to get the background material if you've not been there. When you get that, you fix it and insist that these matters are done on time. In fact, on time. And in the first instance, you should not have any matter which takes more than 2 years. The second instance, you are getting to 18 months. The third instance is 12 months, and it is doable. If the prosecutor does not want to do their matter, they can as well keep them or prosecute on their own. The Chief Justice Emeritus, my good senior, David Maraga, always told everybody, bring your evidence, we shall deal with it. If you don't bring your evidence, don't we have mechanisms for dealing with the matters? Because Backlog, people bring their matters here and they go to sleep. You bring a corruption case or any other matter which is a criminal, etc., and you go to sleep. I mean, litigation is a business. They are professional litigators. What they litigate, we do not know. I've learned that from those who are in the judiciary earlier than myself. Those who have worked in the judiciary have that advantage. My spouse was here for 38 years. She retired the other day as a junior officer. Don't get worried. A good, the Honorable Attorney General. And we know that there is business in litigation. There is business in delaying litigation, etc., etc., etc. If we see it as a combined force of the judiciary, we'll be able to eradicate this, to stumble at.
My Lord, forgive me for interrupting you, but you've been a judge for 8 years. And even if you haven't worked in the corruption court, I assume that you have some knowledge of the workings and the impediments that face the judiciary. You are now Chief Justice. What steps, what practical steps would you take to eradicate some of these problems that you're alluding to?
One, identify the issues, the problems.
The problem is delay in determining cases that touch on corruption.
Get to the courts and address the officers who work in that, the judicial officers who work in that court. Get to the court and address the administrators of that court. Get to the court and get their experiences. Why are we not able to deliver? Why do we keep a matter here for 3 years, 5 years, etc., etc.? When you have that, get to set targets, clear targets, which are permissible, acceptable, or doable. You will be able to know from the experience, you'll be able to give you data on what is doable and what is not doable, and why it is not doable. When you have all that knowledge within yourself, you devise strategies which make it work. I know it can work. I know it has improved. I don't want to mention names. I know it has improved, and it is coming out well. It can be done.
Thank you very much.
Honorable the Attorney General.
Last but one question, my Lord.
Please do.
Is the judiciary independent?
The judiciary is independent. I'm very, very happy about that. I've been here for in July it will be 9 years. Nobody whatsoever has wanted to interfere with the matter I was doing. We can feign a lack of judicial independence, or we can be participants in that non-independence. When you create situations which mar or stifle or stumble your independence, like corruption, you are not telling me that you are involved in corruption and then you are also doing an independent, you are independent as a judicial officer. Zero. That is not the reality. The judiciary is important. I am a living independent. I am a living example. Nobody in 10 to 9 years has interfered with my decision making. Look at it all over. Who has come here to hammer anything on the judiciary? What haven't we done? Presidential elections, and they walked free. Very sensitive matters, and walked free. Let us not point at anybody. We are independent. If there is an issue of lack of independence, then we shall say that we are our own worst enemies. We collude to create non-independence. So far as I'm concerned, we approve 1,000%.
What role do you think the other two arms of government should play in protecting the independence of the judiciary, and how would you, as Chief Justice, encourage that?
One, the issue of a constitutional government, starting from the judiciary, going to the executive and the legislature. And a constitutional government which also appreciates constitutionalism. We have had some very good writing by my good friend, the late Professor H.W. Okosogendo, Constitutions Without Constitutionalism. That is where we start and end. Because you are singing this, you are doing this. You preach this and take the other. If the other arms of government took constitutionalism seriously, this country would cure within a week. If we all took it upon ourselves to practice what is right, to eradicate impunity, we will not require a week. Do you remember the NACA revolution in 2002, which lasted only 11 days? We were there. We had it. We can have it. With the participation of all the stakeholders, the executive, the legislature, and ourselves. Combine and liberate Kenya. That is what we are called upon. That is why we are paid so heftily by the Kenyan taxpayer. Did I answer?
I'm much obliged, my lord, and that will be all from myself. Thank you very much, Honorable Chair.
Thank you so much. It's been a big pleasure, and always welcome, my senior.
Thank you very much, Your Honor. I would like to ask Commissioner Gishohi to continue the questions.
Thank you, Chair. Good afternoon, Judge.
Good afternoon, sir.
Yes, I'll be very brief because most of the questions have been alluded to, but do allow me, if you don't mind, Honorable Judge, just to focus more on the Commission. And I want us to remain with the Commission as much as possible. You have reflected on this period, 2011 to 2016, the foundation, 2016, 2020, 21, sustaining. I want to be very clear. If you get this position as the chairperson of the Commission, just one thing that you'll be able to do or to initiate to deepen, broaden what you asked, what the Honorable Chief Justice previously in those two periods have actually put in place as far as the Commission is concerned.
Insofar as the Commission is concerned, on transformation, I would bring up the Commission to appreciate its position vis-a-vis the judiciary. One of the biggest issues we have today, and it was mentioned on Monday by my good friend Justice Chitembwe, is the issue of management of complaints. That is the elephant in the room. If you ask me, I'll write 1,000 pages. I'll tell you a story for 10 weeks on what it costs, the opportunity cost of answering a complaint.
Complaint?
So what we are saying is let the JSC take a decisive role in dealing with complaints. I don't know whether Commissioner Gishoyi, not Gishoyi, but the representative for Advocate Macharia is here, and I want to use my example. You want to please allow me that.
Without going through the details about it.
Yes, in 2013, I get a complaint. In 2015, we deal with it, and I am successful. In 2019, the same complainant brings a complaint against 6 of us. 5 in the Employment and Labor Relations Court, 1 in the High Court.
Okay.
And the JESC forwards it to me for answer. That is the issue.
Okay.
What is the capacity of managing these complaints?
Very good, Judge. That's a good complaint. I want you to look at the issues, and it was raised earlier on, that you are the chairperson of the commission, you're the Chief Justice. And I want us to focus on the organs of the commission. Organs, not individual offices, organs that you can utilize, that you can be able to touch, that can you be able to make those changes. As chairperson of the commission, as Chief Justice, could you share with us those organs within the commission that you can either strengthen or establish or abolish?
I am not versed with the workings of the Judicial Service Commission. I will not score 40% on that one. But I can mention the areas which I would touch, and then maybe it can be linked to the organs, so that when like the issue of complaints, the body behind that one would have to be streamlined.
Two.
The issue on the growing of development would have to be touched on, because this is where our infrastructure is infrastructure and the other materials that we utilize, like the ICT is anchored. We would have to touch that. The issue of human resource
Good.
is very, very critical, because without human resource, we are as good as dead. We are not in business. We can have all the courthouses, all the buildings, all the it will not be any business. So those critically are the 3 areas that I would like to touch. Start with.
Let's take human resource, because that's very critical.
Yes.
And you talked about making the staff happy, not to fool around, and you talked about a result-oriented approach. I want us to focus on customer-oriented approach. You have been saying about being happy and the rest. Were you to have the customer-oriented approach to make sure the staff are able to produce in terms of productivity? What would be your targets? What did you do to make sure that you have a very clear strategy on how you are going to motivate your staff?
One, let us agree that staff will require facilities to motivate. Staff will require education, training, because I could as well give you an elephant, but you do not appreciate the value of an elephant. So it is not a serious business. Education and training to be able to understand where we are, what we are doing for them. I will allow staff to have their liberty. In fact, if I became Chief Justice, like I suggested 3 years ago in a colloquium, I would allow every officer of the judiciary in their respective capacities to, if they choose, form trade unions. Why? Because it is easier to deal with something which is organized than to deal with a hazard and amorphous things. Groups. We have quite a number of suits on salaries. We have issues of confrontations between the JESC and the staff, etc. This can only be achieved if we have a structured system for those staff members to deal with us. It would even be time years. And a better way of dealing with it, because we don't have everybody working individually to deal with their matter.
Very good.
Please.
Talking about training and developing the staff, I want you to focus on the role of GTI. And as chairperson of the commission, where would you place GTI? What kind of facilities would you give that institute to make sure that it is able to give the service to the staff and to judicial officers also? GTI.
The JTI, today is not the JTI we had 8 years ago. JTI was big, it was brilliant, and it was very, very good. You'd go there and meet on international, conferences. The JTI I anticipated even from then was a JTI which was a complex. I'm not quoting or copying anybody. This is my experience the first time I landed at the JTI. A complex. We do an institution which is self-contained, which is good, which is a good to go.
So what has gone wrong?
I would not know. Earlier I said that I'm not an insider, and it was not.
But Judge, you've been here for 9 years.
Is that insider?
Yes, 9 years long enough. 10 years, kid is going to primary school.
I think we may have to revise our English.
Okay.
Insider means somebody who is actively involved in the administration of the judiciary.
Okay.
I am a judicial officer. I'm inside, yes, but at the periphery.
At the periphery.
Those